Cheers.
Good bail hearing today.
Thank you.
Nice one. Very
Yes,
good.
it was.
It was a
Thank
difficult
you.
case. Good for you.
Very difficult. When a death is involved, it's not easy to get people out.
No, it's very serious, but, again, good work.
Thank you.
Person
So-
should be out on release.
They should. So this is fruit salad part 2,
Yeah, so again,
minus the kiwi. from
it's going to
RC.
be fruit salad, yummy,
minus kiwi.
as the Wiggles would say, because there's a couple of issues.
Why can't you
we
say
wanna
minus
cover.
kiwi for your wife?
And minus kiwi.
Okay, well,
You don't want me to get sick.
no,
I
you don't.
Okay, so I need to talk about two things, okay? One is a short case study. And it's the charges withdrawn.
Excellent work.
Thank you, but it just involved f***ing reading. And I want to preface this again, how it's very easy for somebody to be charged with sexual assault,
Really?
and how the police will only obtain a snippet of information.
Well, we've talked about that a lot. The investigation consists of one statement, maybe?
Right. And one of my pet peeves is how they receive...
Just one?
I have many, but
I know.
one of my major pet peeves is how they will take messages from a complainant.
Selectively. Are you going to say selectively? I'll let you do
How does
this.
it happen? Just talk for a moment, and then I'll...
They get messages so that the complainant, or the victim as some would call her.
Don't say that.
I know. It makes you all jittery. Yeah, I
Please
know.
don't say that.
Stop, pause. Okay, blood pressures. They will ask her or him, but mostly her, to provide the text messages. So she does the selecting and the editing sometimes.
That's correct. So in this case, we have two young people who are dating, and they're young. And innocently one day, she goes over to his place, and they're studying, but he discovers a bottle of whiskey.
One thing leads to another,
And,
allegedly.
And that his parents have in some cabinet. So they share the whiskey, and they're not really interested in studying. And then one thing leads to another, and they wind up having sexual relations. And it's not the first time that they've had that, but that's not really that relevant. But they're a couple. And they part ways fine. But then over the next couple of days, as we understand the statement of the complainant, they get into arguments via messaging, because young people don't pick up a phone.
They don't talk anymore.
And talk to each
No.
other. Everything's on messaging. And,
Which many times helps us, right?
well, God bless it now.
I know.
But it's just funny how these young people communicate. And you can read, because I've had the benefit of doing an extraction and getting all the messages. But they get into an argument, and at that point, about 2-3 days later, the complainant's starting to say, well, you sexually assaulted me, and you should own up to it. You should tell your parents what you did.
Here we go.
You should tell your parents what you did, or I'm going to go to the police, and you're going to be charged. And then the client, this young kid, starts to get really scared, going, I don't remember things the way you do. And they have a debate about it. But he starts to apologize because he's scared.
Right.
She goes to the police anyways and gives only a selection of messages that are screenshotted and emailed to the officer. She gives a statement. He's charged with sexual assault, uttering threats, and I think an assault. It goes through the pretrial phase, gets set down for trial. We're preparing our 276, 278. The client was able to provide us with messages, but some were missing. We were fortunate to be able to have an extraction done by our tech experts.
Explain what that means.
Messages on your phone, when you delete it, if you're using certain apps, they cannot be retrieved. They're gone forever.
Snapchat, etc. Sometimes.
Snapchat, Instagram, and many others. And in Chinese community, they love to use WeChat. That will disappear too. But if you're using iMessage, sometimes they're recoverable.
Yes.
And if it's over your text, which is your cell phone number, they're recoverable. And so we were able to recover additional messages, including a series of Instagram messages and other app messages. But we got a really good, robust
history. Right.
of messages from just before that time they met, right up into the time that he was charged. And we decided to not disclose earlier, but to put it into our application because that allowed us to draft the application with his evidence and our defense narrative and put in an affidavit and put everything in chronology and then juxtapose it with her evidence.
What do you mean by not disclosing earlier?
So sometimes when we have compelling messages or a video like you're about to...
Like me tomorrow in court.
Yeah, you're about to give to a Crown attorney and view it together. Sometimes
well, not together. That'd be awkward.
Well, you have popcorn.
Huh? Well, yeah, if popcorn's provided, I may stick around.
You know, sometimes we open our brief and we'll disclose our messages to the Crown ahead of time with a view to maybe having a discussion as to reasonable prospect of conviction and having it withdrawn. But sometimes I make, sorry, I didn't mean to kick you. I'll make the strategic decision not to disclose because I want this to go down a certain path so that I can get our narrative out at the pretrial phase, which will be in front of a judge. So when we're doing our motions, like we've spoken about a million times, it's in front of the trial judge, typically when you're in the lower court, the Ontario Court of Justice, and I want the trial judge on the motion to be able to read our defense.
So wait, pause, stop. Is that the right order, Marcy? Pause. So explain to us the strategic decision not to do it earlier versus later. What pushes you to hold off?
If I have enough evidence that's demonstrative, that's independent evidence, that would blow it completely out of the water,
then you'll disclose it.
Then I'll disclose it early.
Right.
Because I know that the Crown can't get around it, and they'll do what's right and they'll pull it, like what you're going to have tomorrow.
Yeah.
I don't know how you get around that.
I don't know how you get it. No, that was some sex tape.
Yeah. So, but there's sometimes you have what you know is good, solid defense evidence to support your narrative, but you need to tie it together.
To a story, yeah.
And I have to think strategically, and so we've now used these applications like we would have used a preliminary inquiry, where we then carefully draft out the notice of application to lay out the defense in excruciating detail.
Defense disclosure.
Weave in all of the messages that we're going to be using, and then have the affidavit of the client, which will be his defense as well, and do it in a very methodical way so it's all carefully laid out. So I know the judge who's going to be presiding over the motion, who's going to be the trial judge, will have already read this. And in this, there was messages that was extremely concerning.
Tell us.
The messages, first of all, have our client talking with the complainant, chatting.
Yeah, they're not
chatting about certain events which were the ones that made her upset. She had just talked about sort of how they had a bit of an argument but never spoke about it. Now we have the actual messages, and you can see how that developed. And that was extremely important to understand the context as to why the complainant got angry and then turned on our client. Yeah. And then once turning on our client, the messages then are not just our client saying, "I'm sorry," the client going, "Hold on.
What are you talking about? That's
not what happened.
Yeah.
And you weren't that drunk. We had a couple of drinks of whiskey, but you were fine." And then the client, to his credit, this guy's going, but he actually said this, "But you consented. You wanted to have sex." To which one of the crucial messages back was, "Yeah, I agreed, but I wouldn't have agreed if I was completely sober." And he's like, "What are you talking about? You weren't drunk." "Well, I had some drinks."
Pause.
Think about that, okay?
Yeah.
Not disclosed by the complainant. This was a really critical exchange.
Yeah.
And so the complainant had actually said, "Yeah, I agreed, but because essentially I had a couple of drinks, I wouldn't have agreed." That's bullshit.
Yeah, of course.
And it's still consent. And then it goes on even more, because the complainant had said in her statement that she was so intoxicated she couldn't really remember what happened. Basically, she was like a rag doll. in the exchanges, when he's pressing on, he says, "But you remember all of this?" And she's like, "Yeah, I remember it, but I wasn't completely sober." It's that line that keeps coming out. Contrary to the statement where she says, I really didn't remember much about it. I woke up at spur. So it was a complete contrast.
That's huge.
I did not determine when we were doing this that would be enough to disclose at the early stages unless I put it all together. And there were other messages because she was saying how, and then we see this so often, how the accused, our client, had pressured her to drink. And of course, that's a typical line used. And we see this with adult complainants too.
Sure.
And we're talking adult complainants who are like in their 40s too. It's like it's always the guy who's pressuring them to have something to drink. And he was saying, you liked the whiskey. You wanted to try it. Yeah, I was curious about it, and it didn't taste bad.
That was in the messages.
Yeah.
Wow.
And so when you just put it all together, it was really kind of shocking.
Yeah, I get the strategy versus disclosing it ahead of time.
I just didn't feel in this case it was enough without me packaging it correctly. Right. And I have to do the application anyway, so we did it.
Well, like we've said, it's storytelling. It would have been a partial story.
Yeah, and I wanted to be very careful. So the messages, you know, there was just so more. It was like he because many people don't do this. He challenged her and said, "You wanted to have sex." Yeah, I did, but again, I wouldn't if I wasn't completely sober. If I was completely sober, it was just over and over and over. It was just really astonishing to me.
Thank God for iMessage. What would we do without these messages? Seriously.
Well, because at least that you can recover.
Right. No, but just generally speaking, thank God for all this digital stuff now. It goes a long way.
It really does. And so what was painted here in this application was a lot of messages that we were able to recover that showed a really good history. Mm-hmm. And then you see the client increasingly get scared because of her increasing aggressiveness, saying, I'm gonna get you charged. Right. You got to go to your parents, apologize. You got to tell them that you raped me. You got to tell them that you got me drunk, or I'm going to do this. And the guy's young, and she's young, but he's fucking freaking. And he's like, okay. So when she gave the portions where he apologized, there's no context to that. Yeah. And again, that evidence can get in on trial without any real voir dire. It just goes in, unless we contest authenticity, which we don't because it was a legitimate message he sent. But without the rest of it, it doesn't get explained. No. And just think for a moment that if our client, if we weren't able to recover the actual messages, that type of evidence would go in with an apology.
Right. Doesn't look
without
good.
all the other messages. So there is this very stark contrast as to what is the true context, the true discussion, the true narrative versus this little fucking small narrative that the complainant wanted to put together, which was an absolute lie.
At the end of this, did the Crown reconsider?
Wonderful Crown.
But did they think about, so pause?
Wonderful Crown attorney, read everything, at first blush responded to the application.
What did she say?
I'm not going to get into what they said, but it was trying to block our messages.
Okay. Well, that's all.
Then we did a reply.
Right.
And then after reply, I think the penny dropped. And then the Crown took a step back, conceded stage one, had discussions with us, and said, "You're right. I have no reasonable prospect of conviction."
Wow.
So I commend her. And Crown attorneys are overworked. So she had to sit down and she had to really read. And I said to her, "You got to read." I've laid it out in, it was like a 75-page.
Yeah,
it
was great
75-page document with everything. And we were able to authenticate because we had an extraction report. So there's no issue about authentication, even though you don't need authentication. The accused can testify to authenticate the messages to who they're from.
Affidavit.
But we had all that evidence. And so the Crown, very good for her, decided there's no reasonable prospect of conviction, charges withdrawn.
Huge.
But this is, so I keep doing this because it's like every other episode, it's like we get another case where
Same
it's
patterns.
where it's the same patterns. And it's the same problem when, I faced the bullshit about
Selective
allegations.
editing.
Allegations, false allegations are rare, and now I'm getting even more mad now. I think I'm coming to the point now where I'm going to be insisting and saying, in a disclosure request, seize the complainant's phone, and you do an extraction from the phone. If you're going to put forward 3 or 4 messages, you better get all the messages.
Right. I've started doing that. I want the full extraction.
But
Period.
they don't care.
No, they don't care.
Like, it goes nowhere. Right. And I know it goes nowhere, so I've kind of asked, but I never really cared about it.
Right.
Because they don't do it anyways.
Right.
But now I'm almost at the point where I'm almost thinking that we can construct a constitutional argument.
Pretrial disclosure motion. Yeah.
Pretrial, say if you don't do that, then we want to stay at proceedings.
Right. Well, it's not an accurate picture. Come on, Crown.
Or the lesser remedy is an exclusion of their messages.
Right.
If we're not able to get the full dialogue. Like, what do you think about that as an issue now? Do you think it would be a viable argument to say, if you produce 5 messages and we know there's 300 messages and it's taken completely out of context, that we could bring a motion to exclude those messages because the police have not seized her phone and done a forensic review and tried to extract the full thread of messages, and or maybe a stay of proceedings?
Well, step 1, we want an order for the production. Step 2, we want the police to seize and do these, what's it called, celebrate extraction? The software?
Celebrate, yeah.
Celebrate. And step
That's
3.
the software. But
That's the software. That's neither here nor there. And step 3, no, okay. Stay proceedings, please. Maybe costs.
what do you think? Are we there?
I think we're there. I think we should start doing it. It's like basic disclosure.
But you know what I'm thinking is that...
It's like in the olden days, if a complainant was to provide 3 pages of her diary versus the entire diary. That's the analogy.
Here's what I'm struggling with. Mm-hmm. And we're sitting on this information. We're sitting on hundreds of cases of solid evidence of fabrication. Solid evidence of complainants who selectively produce messages in order to distort the truth. Mm-hmm. That is a robust source of information to ground these applications in.
Yes.
To say, although it's not in this case, this is a solid enough foundation to show this type of practice by police to produce this and then use it in prosecution does an injustice. And therefore, the only remedy is to provide us with everything.
Give us everything.
Or you exclude it or it gets stayed.
That's right. We should start doing that very soon because we've got a lot of these cases.
This was the most recent case that caused me pause to go, we got to do more.
Because there is more. More's available. More is out there. That's the bottom line.
And, again, thank God the client's parents were able to afford the forensic examination.
Oh, God. What does that cost, roughly? Tell people.
This wasn't so bad. It was about $3,500.
It can go much double.
But it can go up to 7, 8, 9, 10,000.
Easy.
But it's still a lot of money for people on top of affording lawyers and on top of affording the drafting of the application and everything else. And then, you know as well as we do, when we book the trial time, when we book everything else, all those costs are involved. It's not like we can just say, thank you, I'm sorry, we're not charging for that time. But for those who can't afford this, boy, they get f***ed over.
Oh, totally. Why can't we subpoena the complainants?
Always an offspring calls. Just 1 second.
It's about the burrito, probably.
Hi, Rachie. How are you?
Oh, it's Rachel.
Hi, Josephine. I'm good. How are you?
Good. Can you say hi to all our viewers for the podcast?
Hi. Guys, please like, comment, and subscribe.
Aw.
She does it better than you do.
Yeah, you did it better than I did. Thank you. And what?
For more content.
Thank you, honey. I love you. Can I call you afterward?
Sure.
Okay, bye.
Bye.
It's a family affair, the podcast.
No, there's a child that asks for food or, calls, and these are adult children, okay?
I'm waiting for my Frenchie to call.
Your doggy.
Yeah, my dog. Uh-oh, you're pounding.
No, I just
Okay, why can't we subpoena her phone? Disclosure motion.
we can.
Yeah, so we got to do this stuff.
But that's our obligation then. Just think about from a cost standpoint.
Right, I get what you're saying.
Well,
it's like the case we were talking about with me. So the Crown, remember, has 5 occurrence reports. This is a sex assault trial.
This is excellent.
So I have a sex assault trial coming up, a couple of weeks. Crown contacts me, says, oh, by the way, I'm in possession of 5 York Regional Police occurrence reports. involving the complainant. And I said, oh, thanks for telling me. We got a trial in 2 weeks. Can I have them? Well, no, you can't. What do you mean I can't have them? They're in your possession, right? She goes, yeah, but you can't have them. I said, okay. Can you blink once or twice if this involves her being a complainant or an accused, these 5 cases? No, I can't do that. Policy, privacy, you're going to have to bring a motion to get access to this stuff. I said, how can I bring a
And the occurrence reports are in the Crown's possession.
Crown physically has them, right? Physically. This isn't a case of, okay, we got to subpoena York Regional Police, bring a motion to get a judge to review an order. The Crown has them. She won't give them. And I'm like, okay, that's kind of ridiculous. So we had a further judicial pretrial today with a pretty good judge. And he's scratching his head saying, let me get this straight, Crown. They're in your possession. They are obviously relevant because you've alerted the defense to their existence. So either she's, again, a complainant or an accused, but you don't want to give them to the defense, and you're forcing the defense to bring a motion. And let's translate what that equals. That equals basically a reverse onus. We're drafting, we're filing. It's an added expense to the client.
It's an access to justice issue. That's what I'm talking
Right.
about. So without going into so much of the pretrial discussions, it's an access to justice
Right.
issue. So everything is foisted upon an accused.
Right. It's like a reverse onus. You go get them.
So you have to issue a subpoena. So
Right.
it's not that hard. You go on the
Yeah.
computer system, you fill it out, you can e-file it, get it signed, get it back. But then you have to file it,
Serve it on
serve
the
it
police.
on the police, get them to come to court, and then you have to draft a motion with a factum.
Well, again, not getting too much into the pretrial, the judge was saying, but they're in your possession. Well, the Crown's position is, well, yeah, they're in my possession, but they're police records, so you still have to subpoena the police.
Yeah, I think you should just subpoena the f***ing Crown.
Whoa, bold. Yeah, I know.
But this is the silliness of this.
It's just ridiculous.
But to me, again, we come to an access to justice issue. So we have to spend the money of a client to do something that should automatically be done.
Yeah. Like, what's the downside of releasing this to us? What is the
But
downside?
why are we to be? Let's say it contains sensitive information. What we're gonna go on the podcast and f***ing read it to
Yeah,
people?
yeah,
like,
no.
of course we're not going to
No,
do.
we're
that.
officers of the court. We're going to do what...
We're never going to do anything like that.
No.
How many times have we received in the past sensitive information that we keep under seal?
All the time.
We look, we have it in a very special place. It's not,
Right.
it goes back to the Crown Attorney. Like, that never happened. Like, there's no leaking of this f***ing information.
No. And what's the privacy interest? And the judge even... What's the privacy interest in a public proceeding that's happened? It's finished. It's not pending. 5 occurrence reports have concluded matters. He said, they're public. Right? Like, so yeah. So I have to bring a motion now.
So that's a great, another example of what to me is a skewed way of dealing with matters that should be done by the police and by the Crown and disclosed to defense, and it's not being done, and it's foisted upon the defense, and it's an access to justice issue, it's a financial issue, and in many respects where we don't have the resources to do it, or we don't just do it on our own, even with no cost to the client, which sometimes happens.
Of course.
The clients will suffer.
This client can't afford a full-blown motion, so yeah, I'm going to have to...
Well, we eat fees all the
We're
time.
going to have to pro bono swallow some of the fees here. But I'm like, I told the client, we have to do, like, this isn't an option. Okay, we have to do this. She could have been charged as a complainant with public mischief, false allegations. Who knows?
Yeah, you've
Who knows
no
what's
choice.
in there? I have no choice. I have to do it. Be negligent otherwise.
So you know, at this last case that we had amongst all the other ones, and you look at these and it's like, we're fundamentally getting it wrong here. There must be a better investigation where you seize the cell phone, extract the messages, get consent from the complainant
Seized
to go through
every
it.
cell phone in sight.
Why not seize the
They
accused?
they do seize the accused virtually automatically.
Yeah, well, I mean, we read search warrants all the time for searching their phones.
Yeah. Why can't we get the complainant's phone? Especially if it's clear there's been an interaction.
I don't want to be forced to do this. I want
right.
the police to be doing
Right.
this as part of their
Investigation, right.
Don't just take,
A slice of the case.
don't just take, a picture of a series of messages that the complainant then emails you.
Oh, God, I had one of those. It was like screenshots of her iPad. Well, can I see all of the messages, please?
And then let's talk about metadata. You just get that, and you don't even know if it's legitimate.
No,
sometimes.
of course not.
Because I've received messages in a format I'm like, I don't. What
is this? Yeah.
It's frightening. So let's just segue for 1 second because it ties into an interesting case from the Ontario Court of Appeal that came out just recently.
You have it? Okay.
Yeah, Reimer. So it's Rex versus Reimer, Reimer, 2024, ONCA 519. A very recent decision.
March,
Typically brilliantly written because it's Justice Pachaco, and it's interesting because.
Why is it interesting?
Well, again, it involves sexualized messages, and to me, it's about the injustice of the system.
Okay, explain.
Okay, so Mr. Reimer had met this person over Plenty of Fish, which I will tell you is a recipe to get charged with sexual assault.
And it
If
still
you
exists.
you go on Plenty of Fish to find a date, you're probably standing about a 50% chance you're going to be charged with sexual assault because I've had more cases out of that one dating app than anything else. But anyways, they meet, they start messaging, and then eventually they meet, have a small meal together, go to a hotel, and there's sex, and then afterward he gets charged with sexual assault. He brings an application under Section 276 of the Criminal Code to advance these messages that he has prior to the sexual
Prior
contact
to the alleged incident, yeah.
that are sexualized messages.
And they describe what he wanted or what they wanted to engage in at the
Even
motel.
more importantly, that's right, they describe what she wanted him to do.
Right.
And so it is communications that were relevant to the activities that they were contemplating to do, that she wanted to be done, and it went to essentially her consent for these, okay? So the application was brought at trial, and the trial judge ruled that the sexualized communications were not admissible because they were offending the myth-based discriminatory reasons that 276 is supposed to screen out. They were irrelevant. They were being offered for the legal purpose of proving the complainant consented in advance to sexual activity that occurred, which is a misnomer, and the use of the evidence depended upon impermissible inferences, like that she was less worthy of belief or she was more likely to have consented. So there's two important things here. And I know we're running along on this, so I won't spend tons of time on this. But what was very important to me was that in this case, Justice Pachaco did an extremely brilliant analysis in plain terms, laying out why the judge's ruling was wrong. It's being sent back for retrial and for the motion to be reheard. He didn't make a determination as to whether the sexual messages ought to be included, but he did say that the messages are relevant, and they're relevant to consent. And there's another aspect of this case that's important, but this is what I really want to talk about. So these types of messages that happen in or around sexual activity are really f***ing important because things just don't happen in a goddamn vacuum. Nope. Okay? And Section 276 was to screen out other sexual activity that would then trade on impermissible inferences, so these myth-based inferences.
Twin myths, etc.
Yeah. That were related to the actual nature of this. I want to get the right language, but the nature of the sexual activity. So it's the sexual activity itself, and there's a difference, and it's subtle, but it's important.
What's the difference?
Just give me 1 second, because I want to read this
read it,
in a way.
It's a good. He phrases it well.
So let me try and make this simple, because I know one episode we did when we were reading from a case, people found it a little confusing. So these text messages were statements about what the complainant wanted to happen during the sexual activity, and it truly did speak to what she was contemplating they were going to do and going to consent to. And even though individuals could say things that they do not really mean, or they are capable of changing their mind, that's absolutely true.
Totally true.
And Justice Pacheco said it's an
Incontrovertible?
say that again for me?
Incontrovertible, I think.
Yes, proposition of logic and human experience.
It's a big word.
I know. That is, I'm just tired.
Yeah, I know.
That a statement of present intention to do an act at a future time increases the likelihood that the speaker will engage in that act on the future occasion. Because of the sound logic foundation for this kind of reasoning, the law of evidence has recognized a hearsay exception that admits statements of present intention as evidence that the speaker later carried out the intention. I won't go into that case because I don't want to complicate things too much.
Yeah, that's a tricky area.
But it was open to a trier of fact to find that the sexualized messages represent serious expressions of intention, increasing the likelihood that the complainant later acted consensually. As Justice Doherty pointed out in the case of Regina versus LS, evidence does not have to establish a fact to be relevant, nor need it be determinative. It must simply have some tendency in logic to increase the probability of the fact inferred. Some of the statements in the sexualized communications clearly met the standard of relevance required for the admission. If the complainant indeed made the statements, it would be relevant on the issue of consent.
Imagine.
As a statement of her present intention to consensually engage in those described acts a short time later on, in this case at the motel.
That was a wish list.
Derivatively, the sexualized text referenced in the statement would also be relevant since they provide the details of the act she communicated her intention to engage in. So, pause.
Pause, yeah.
This, previously, you will get time after time after time, if you try and put in messages where people are talking about the sexual acts they want to engage in, they're not relevant because consent has to be contemporaneous at the time that you're having sex, okay? So consent has to be at the moment you're having sex, okay? That's called the contemporaneous rule that it has to be
at the time.
At the time of the sexual act.
Right.
And so the argument will always be that any messages about these discussions are not relevant. And sometimes lawyers would try and characterize it as narrative, in other words, explaining how and why they got together and what happened, which is generally not allowed, and it's not f***ing narrative. No. It goes to the issue of consent. Right. And God bless Justice Pacheco has now conclusively made this clear.
That's huge.
That there has been a misunderstanding of the rule. So he said in this case that he was persuaded that the judge erred by accepting the submissions of the Crown and complaints counsel that the earlier expressions of consent were not relevant as a matter of law because consent must be given at the time of the sexual touching. This rule has no application to the lines of reasoning that he discussed. Neither of those lines of reasoning depend upon the theory that the consent that the complainant expressed earlier was the consent provided in the motel. They depend instead on the theory that her earlier statements of intention and consent are relevant to the question of whether she did, in fact, consent during the meeting in the motel. So this is a conflation of the law of consent and the law of evidence. This is evidence that she may have consented to the activities that she specifically discussed that she wanted to engage in and was communicating what her consent was. It's just evidence.
Period. Yeah.
Going to the issue of consent. Yeah. And therefore, it is relevant and capable of being admissible.
Yeah, it's a big case, and I don't think people yet realize how big it is. Because you know how many times I've had judges say, no, you can't go there, narrative. I said, but they discussed a wish list. We're going to do this kink. We're going to do that. Here's what I'd like. Text or verbal or otherwise. No, Mr. Burry, you can't go there.
And that's wrong.
I know.
The fact that consent must be contemporaneous does not mean that evidence relevant to the factual question of consent must also be contemporaneous. And that goes back to the day of Ewan Chuck, which is the seminal case about consent. And as noted, the complainant's words and actions before and during the incident can be considered in determining whether a complainant has consented at the time of the sexual activity, so long as the earlier words or actions are relied upon because they have a tendency in logic and human experience to support the likelihood that the complainant consented at the time of the sexual activity. They are not rendered legally irrelevant by the contemporaneity rule. In my view, the trial judge misapprehended the rule, erring in law. So incredibly important.
Very. This changes a lot, and a lot of the nonsense we've had to kind of scratch our heads at with some judges that just get it wrong.
And here's the other issue. So in Section 276, twin myth reasoning, meaning that a person is more likely to consent because they've engaged in consensual sex before, or they're less worthy of belief because they've been engaging in sex before. These are myths. They're discriminatory beliefs. Just because you consent to sex before doesn't mean you're going to consent now, or if you had sex a lot doesn't mean you're less worthy of belief. That's just f***ing bullshit, and we know that's all archaic, discriminatory beliefs. But the section is very important because it says twin myths relating to consent prohibits the inferences that the complainant's prior sexual activities, by reason of their sexual nature, is what I said at the beginning, make it more likely that she consented to the sexual activity in question. The relevance of the sexualized text does not derive from the sexual nature of the complainant's activity of sexting. It derives instead from the fact that those texts communicated the complainant's intentions about what she would do and agree to at the upcoming meeting. It derives from her stated intentions relating to the specific occasion in question. This is incredibly f***ing important.
It is.
Because this has always been the law. This has always been the law. Going back decades, because the 276 was found to be constitutional because you could still argue this.
Right. But they were getting it wrong for years.
Many courts were getting it wrong, and many courts were saying you cannot rely on messages about discussions about the sexual activity for precisely what you said, because it goes to narrative. And consent. It has I've heard this a million times.
Same here.
Consent is about what happened at that particular moment, not what before. Prior consent does not be consent, and that's true.
Right.
But it is relevant to the question of consent.
Right.
And
it's
this
a piece of the puzzle.
decision is an excellently written decision that talks about. There's something else in here that talks about the subject matter of the offense. I won't get into now. I think it's something we can leave to another podcast. But this flows from our discussion today about. I'm just going to put this down so I can sit up a little bit straighter. From our discussion about the importance of text messages and messaging. In this day and age, where people communicate so much by messages over all these apps and iCloud or whatever it is, iMessage
WhatsApp,
and everything else.
Whatever.
It's so important to have access to these messages and for courts to realize there's a wealth of evidence in these messages that should not necessarily be excluded but should be included because it actually provides you with relevance to the consent.
Right.
It's so important.
I sense a paper being written.
Well, we've summarized, not to be bashful about self-promoting, but we have a newsletter on sexual assault case law that we update, and it's published through Thomson Reuters, and it's an excellent newsletter because we take all these cases, we try and break them down. We want to stay on top of it. But we're going to do a blog on this. We're going to do a written blog. We're going to do a bit of a paper on it. Because I can't tell you how many times that's the other objection I hear too. Well, consent is relevant at the time, so none of this is relevant.
Right.
And we have to keep hammering away on this because not all these cases wind up going to appeal.
Right. Appeal's an expensive process.
It is. I mean, people can get convicted. They're not able to appeal. That's the end of it.
That's the end. Yeah. It just
and that's
there.
where we talk about the access to there was a thread, even though through this sort of salady sort of episode we had. The thread is messages are important. Messages will communicate important relevance about the issue that's consent in a case. More needs to be done by way of investigation. More needs to be done by way of understanding why messages are relevant and admissible. And more needs to be done about
Forcing the issue.
forcing the issue.
Yeah.
BJ?
Maybe this is a good time for PSA not to engage in messaging threads with people who have disappearing messages turned on, especially if you meet them over plenty of fish.
Right.
Yeah.
Right.
I mean, most of these apps have, I guess, like you can be encrypted or you can have...
No, there's a feature you can turn on that
Right.
says turn these messages, delete messages after
Right.
an hour, a day.
Well, check
Yeah.
your iPhone
So
settings.
PSA
yeah.
into the camera.
Yeah, check your iPhone settings for how long messages are stored.
Well, but it's over these apps, I guess. So you're saying... So this...
All the political people who are all dirty, the
Right.
dirtiest people in the world, they all have it turned on.
Of course, and encrypted.
Well, it's a perfect example then. You don't realize just what kind of evidence you may be erasing,
Right.
right?
Right. You could be saving yourself.
And again, it's like, we're not saying, again, that there are not legitimate complaints of sexual assault. We're not saying that at all. We just have this view because of the cases that we have. And my God, we've been doing this now for what, almost 4 years? So, I mean, I think, frankly, we have a rather robust group of clients where they come forward with real messages and real cases where we show that things are actually fabricated. Again, there are people who are guilty of bad things. We don't dispute that at all. No. But this is a perfect example why this is so important. And when people actually, if they engage in that stuff and they've got that setting to say delete my messages, they may be deleting evidence that could save their ass one day.
Exactly.
And
So, folks, check your iPhone
to me,
settings.
it's frightening because in this case,
But for those messages.
This young person would be going to trial and could very well go to jail.
Right.
Because I could see a judge still relying on the messages that the complainant produced.
Of course.
And then in this case with this appeal, and James Lockyer was counsel on it, they did a great job on appeal. But it was, to me, it was pretty f***ing obvious. But good for him.
Right.
The trial judge completely f***ed up. And
The learned trial judge.
whatever. I mean, they're fallible. Again, I always say we have a good judiciary, but people are scared. Some are scared about, about how it's perceived when they make a ruling on something.
For sure.
But they miss they missed the nuances of the actual law. Justice Pachaco is an outstanding jurist, as so many are in the Court of Appeal, but he does a great job of distilling it, making it understandable.
Yes.
And they've just missed the mark, completely missed it.
Yep.
Got to be really careful with this, and messages are incredibly important to establishing innocence. And I say this because this proof beyond a reasonable doubt is really a real threshold, but it's easy to get convicted.
Oh, extremely.
Pillow talk.
Pillow talk. Okay.
I'm tired. It's been a long
I know,
day.
me too. Bail hearing all day long. What
Do it the way BJ wants you to do it, please,
BJ,
because
can you
these
read
are
it? BJ,
we have to
read it.
order new pillows.
We do?
He doesn't like these pillows. We have to please BJ. We got cake for Max. Now we have to
I don't
please.
have mics, they can't hear me. So what are the 3 words?
Like, comment.
No,
No.
say it properly. Like, share, subscribe.
Okay.
So you can do like, share, subscribe, and then
Comments
you
at
can
the end.
and send us your comment.
Right. Okay, well,
And again,
please read
like
that.
I always say, I love the comments because, again, one of our excellent criminal lawyer out in Manitoba, there's something going on with an MLA there.
Yep.
Wrote to me right away. We're taking a look at it, trying to understand what's going on. Maybe we got it partially wrong, but I think we've done a pretty good job of it. But
Yep.
it's something that needs to be brought to the attention.
It does.
And we're getting many other questions. They're really helpful.
Yeah.
Because we want to produce material that people want to listen
It's
to.
relevant, yeah.
And then it helps us.
Exactly. Win-win.
So thank you so much. Sorry if we were long-winded on this one, but thank you. Have a good night. Take care and see you soon.
We're definitely out of win. Good night.